Welcome to the Southwest Florida Real Estate Update, hosted by the York Group of Downing Fry Realty. Our show will bring you the most up-to-date information on the local real estate market, presented by leading experts in the field.
Welcome to the Southwest Florida Real Estate Update. I'm Morgan York with the York Group of Downing Fry, and I'm joined today by our host Jim York and his guest Celia Deifik, real property lawyer with Lanier & Deifik.
Thank you, Morgan, for the introduction. Well, thanks for coming on the show
Sure.
today. Hey, for the viewers that haven't seen you, because it's been a couple months or you've been on the show, tell us a little bit about yourself.
I am an attorney here in Naples. I'm board certified in real property law, have been since 1990. I'm required to recertify every 5 years with the Florida Bar, which I do. And I use that primarily for litigating real estate matters, real estate disputes of all different kinds. I'm with the law firm of Lanier & Deifik downtown it used to be the Capital Bank building. I think they may be changing the name of the building sometime soon, but downtown on 7th Avenue and the Trail.
Yeah, I know you've helped our customers with questions and everything. You are a litigator and you do know the Florida law. Versus doing closings or
right. I'm not I don't do transactions anymore. Years ago, I did do closing transactions, and actually years ago I used to write condominium documents, condominium declarations, and things for developers, and I don't do that any longer.
So today we're going to talk about Marketable Act,
Marketable Record Title Act.
Okay.
Marketable Record Title.
So I have all these notes here, and I think the law has changed, or things are changing in the law. And so why don't you just start off and where you want to start?
Okay, all right.
So it is complicated.
It is. It's an exotic name, and most attorneys will refer to it by its initials, the acronym MARTA. And what MARTA stands for, Marketable Record Title Act. And what we're really talking about is documents that get recorded in the clerk's office.
That's right. Everything has to be recorded there.
Everything has to be recorded. Unfortunately, I have people come in from time to time who've had deeds in their drawer or various documents in their drawer that weren't recorded, and they get upset when I tell them that it may have limited use at this point. So I think everybody knows what record title means. It means you took a document, whether it's a deed, an easement, condominium declaration, and you recorded it with the clerk of court. So everybody can see it.
Right, and you can see it online.
You can see it online these days, yes. All right. Marketable means that the legislature wants property to be easy to market, easy for you as a real estate agent to sell. That's really what marketable means. And we've had a concept in the Anglo-American law for hundreds of years where the courts are biased against what we call restraints on alienation. And the easiest way I can explain that term is you take your infant and you put her in a child restraint seat because you want to restrain her because you don't want her going through the windshield.
Right.
All right? So a restraint on alienation is where you have something that's recorded with the clerk that restrains your ability to sell the property. And unlike the child seat, the courts generally and the legislature generally look with disfavor on restraints. I gave you the example of my house. I have a house on an acre. My covenants say only one house per acre. Perhaps I wanted to subdivide it, put 4 houses up. I can't because that covenant is a restraint on alienation. So alienation is just another word for selling. So if I hire you and say, please sell 4 lots out of my 1, you look at the covenants and say, I can't. I'm restrained from doing that. Now, over the years, a lot of documents, some with very good purpose, some that are a little crazy, have been recorded with the clerk's offices in the 67 counties in Florida. And many of these are quite old. And so these were piling up and causing people problems when they wanted to sell their property. Restraints can be any number of things.
It can be a dog restraint for
it
the
could be a dog
large
restraint.
Or whatever,
it
right?
could be something having nothing to do with the community covenant.
Mm-hmm.
It's just something saying, for instance, there used to be documents saying you can't sell to certain kinds of people, people of certain color, people of certain religion. The federal government has taken care of that restraint.
That's right.
But there's a lot of other silly documents, and documents that maybe weren't silly in 1902, but are an annoyance now. So in 1963, the Florida legislature passed MARTA, the Marketable Record Title Act, and said, listen, if things are more than 30 years old and they haven't been carried forward in certain recognizable ways, we're going to disregard them. You can't disregard things that are interests of the government or roads or things of that nature. So in 1963, when this law was passed, it's like cleaning out your closet. Oh my gosh, I didn't know I had all those, blouses.
Right.
Now I can see what I have, and I know I can access my closet, I can sell my property. And this applies, of course, to commercial properties as well as residential properties. All right, so 1963, we've cleaned our closet, we're feeling good. In 2007 or thereabouts, the legislature became aware that there were a lot of community covenants that were not necessarily self-perpetuating. So when we think of community covenants, we think about declarations of condominium. We think about homeowner associations that have been incorporated under Florida Statute 720. And they have very defined rules, and they track the statute.
Right.
Most of the time they do. Sometimes they don't. But there are also a lot of neighborhood covenants that are not condominiums, and they don't comply with Florida Statute 720, the homeowner association statute that governs residential communities. They may be older communities where the developer recorded covenants but didn't think about
All this other
stuff because maybe it didn't exist at that point in time, or they did and they didn't want to be bothered with it. So there are many residential neighborhoods that have covenants that are not necessarily self-perpetuating. There were many homeowner association covenants that did strictly comply with the HOA law, but weren't necessarily self-perpetuating.
Right.
So in 2007, the legislature said, wait a second, we're going to fix this. Closet's gotten dusty again. Too many old shoes, on the floor. We're going to clean this up. So they amended the HOA statute to provide a procedure whereby homeowner associations could revitalize their covenants to make sure they didn't expire.
They're updated.
They're updated and they're definitely applicable because there's various ways someone might have argued that they were expiring. And that would hurt property values in the homeowner association, things like that. And that was great. But it was a little complicated. And a lot of boards of directors didn't want to be bothered with it or didn't understand it. So many associations did take advantage of it. The problem is it left out some big swaths of people with covenants on their property. It left out commercial associations, commercial property associations, for instance, industrial parks, office parks, things like that. They weren't subject to it. It also left out neighborhoods that have covenants that are mandatory and recorded by the original developer, but they have no association, or they only have a voluntary association, and their covenants may be expiring. So the legislature went back and looked at MARTA, the Marketable Record Title Act, and said, we can clean this up. And so they changed the language from homeowners association to property owners association.
Right.
And they made the definition more broad for homeowners association. So interestingly, in this Florida statute, which is Florida Statute 712, anybody with, Google can find it, the definition of homeowners association is more broad than the definition in Florida Statute 720 that governs homeowner associations. Now, that new law, which has a lot of aspects, very interesting aspects we can talk about, was passed by the legislature over a year ago in 2018. So your obvious question is,
well, before I get to that obvious question, we're going to take a little short break here because I'm going to wonder why they passed it in 2018, right?
Okay.
We'll be right back with a little short commercial here and with the York Group. Thank you.
Thinking of buying or selling a home in Naples, Marco Island, Bonita, or Estero, Florida? Think of the most experienced York Real Estate Group, associated with the #1 brokerage in Southwest Florida, Downing Fry Realty, which produces yearly real estate transactions of over $1 billion. Jim, Michael, and Morgan make up the York Real Estate Group of Downing Fry Realty, with over $275 million in sales transactions, along with offering over 25 combined years' experience in the local market. The Yorks can offer the experience and trust you need in a realtor. Call them today at 239-273-6727 or visit their website at www.naplesyorkrealestate.com.
Welcome back. Well, the obvious question, right, is why are we talking about 2018 and we're in 2019?
Excellent question. Because the legislature installed a grace period, and they said, they added to the law, and they said, not only are we making everything broader, and we're saying that this should be liberally construed because we want to preserve property values, we want to preserve good covenants where we can, but a lot of people may not realize this. So we're going to give them till October 1 of 2019 to bring suit to get a judicial determination as to whether their covenants are or are not applicable and going to be revitalized or have life breathed into them. Interesting thing is, they also said, if you're in one of those neighborhoods that doesn't have an association but has mandatory covenants that you think may have expired, you can ask a court for a judicial determination that they should never apply to you. But you have to file suit before October 19th, 2019. So you can file either way. But
so it would be an individual filing suit?
It would be a parcel owner because this was an outreach to those people that don't have an association. But again, the law, there's more to the law than that. It now applies to a lot of associations it didn't apply to before.
Right.
It applies to residential property associations that don't fit under the HOA law. It applies to commercial property, as I said, office parks, industrial parks, that never fit under HOA law because that's a residential statute. And very interestingly, there's a brand new 2019 appellate court decision in Florida where they said it can apply to a condominium.
So basically, people should be looking at is how old their covenants are, because we were talking about going back 30, 40, 50 years ago, right? And really developers that maybe just did a boilerplate covenants, right? Just to get by because they're building houses.
Right.
And the board of directors of the association hasn't updated anything, right?
Exactly.
And it could end up being...
Or they have no
not
association.
right, or they have no association. So those are some of the key things that
Sure.
our viewers or homeowners should be looking at when they're purchasing, or they want to update their
Right.
covenants.
It's also important if, for instance, you're in a neighborhood with questionable covenants, who may file a lien against you or may file to preserve covenants that you think don't exist, not just because they're old, but because they've asked to put new things in them. And so this law also says there's a penalty for filing false claims. Perfectly fine to try and revitalize legitimate covenants.
Covenants, right.
But don't go just filing stuff because you're mad at somebody or you hope people won't notice.
Right.
Because you'll be penalized. You'll have to pay the other party's attorney's fees and any damages they suffered because, for instance, Jim wasn't able to sell their house.
Right.
Because this false claim was filed.
Yeah, because you have to have marketable title when you sell a house.
Exactly.
So that's key. Well, I appreciate you coming on the show today, and I've learned a lot, and I'll tell you, it's complicated. I mean, you know, they should be contacting somebody like you if they have questions, and if they should maybe first read it over, and if they have questions, they should, you know, talk to the appropriate person. 'Cause
Sure.
us being real estate agents, we're really not experienced in any of this. We might be somewhat knowledgeable, but I suggest them giving you a call. And thanks for coming on the
Sure.
show today. And
Thank you.
We'll see you next week. Thank you.